The Supreme Court of the United States under Chief Justice John Roberts, and stacked now at 6-3, with Trump appointees being 3 of them. So far, that Supreme Court in high-profile cases has been at pains to not appear overly extreme. For instance, they did not gut the Affordable Care Act on preposterous pretenses. They did not overturn the election. So, good for them on that score. And Roberts has deftly cultivated an image of the court that has won it a surprising degree of approval from Democrats and liberals. In fact, a recent Marquette University Law School poll found that 59% of Democrats strongly or somewhat approved of how the court is doing, which is kind of nuts, actually. It's 2 points higher than how Republicans view the court. But I am here to tell you, this image of a moderate court is wildly deceiving. Because outside of the spotlight, the ACA case, the election, in a series of small paragraph-long orders with little justification, the court has issued a string of stunning extreme rulings upholding lower court extremists. And last night, after the close of business, they did it again. The court upheld a lower court's order that the Biden administration, against its own wishes and policies, must essentially restart from scratch a discontinued Trump administration immigration policy that had caused widespread misery and harm for thousands of asylum seekers. Legal observers called it unbelievable, both procedurally and substantively, and stunning, radical, and terrifying. Ian Milzer, who writes on the court, said, "I'm genuinely shook by what the Supreme Court just did. I thought they were better than this. I thought Brett Kavanaugh was better than this. Yes, it is so bad I now have a drastically lower opinion of Brett Kavanaugh." Here to explain what happened is Melissa Murray, professor of constitutional law at New York University and co-host of the Strict Scrutiny podcast that, in case of full disclosure, my wife Kate Shaw is also a co-host of. Melissa, it was interesting to see the kind of alarms go off last night from court watchers about this order. And I think to explain it, maybe first we start with what category of order this is, because it's not like a big, fully reasoned decision. People sometimes refer to it as the shadow docket, but these are the ways the court intervene in lower court opinions where they don't have to really give a reason. They're doing a lot of this, and a lot of it's been pretty alarming.
And that's exactly right, Chris. The shadow docket has received a lot of attention over the last couple of years. But again, that whole perception of a relatively moderate or nonpartisan court really only holds if you exclude the shadow docket decisions. And in fact, there's been a lot of shadow docket activity over the course of the last term. So these are emergency appeals that are made to the Supreme Court, and the court makes decisions, often in unsigned, very short opinions, where they don't elaborate on their reasoning. We really don't even know who signed on to what parts of the opinion unless the justices publicly signal their disagreement, as was the case in last night's opinion. But again, these are not argued with full briefing and oral argument like regular cases on the merits docket. They truly are in the shadow and often escape our point of view, except when situations like this arise where the decisions are actually quite extreme.
So the Trump administration had something called a Remain in Mexico policy. MPP was the way it was referred to technically, shorthand. And it essentially kind of got discontinued because of COVID. But basically what it was doing was taking people that were showing up at the border seeking asylum and saying, you have to stay in Mexico while this is all adjudicated. That was totally new. There was a huge humanitarian outcry because people were trapped in this horrible limbo. They're in shelters in Juarez. They're being preyed upon by kidnappers, yada, yada. The Biden administration at a certain point says, we're reversing this policy. We don't want to do this anymore. They get sued, I think, by Texas, among other states. And what does a lower court district federal judge rule?
So this was actually quite unusual. So this was a Trump appointee in Texas, Matthew Kacsmaryk, and he not only said that the policy rescission had been explained by the administration, he actually ordered the administration to reinstate the policy pending the appeal. So the appeal is going on, but they gave the administration exactly a week in order to reinstate the policy. So that prompted the emergency appeal to the Supreme Court. So the lower court opinion by itself is actually quite unusual, requiring the administration to reinstate this policy and essentially negotiate with a foreign government over this policy.
Right. That's the part of it, too. There's huge kind of implications here, both for the folks that are on the border and also American foreign policy. It's a lower court, a lower district judge saying, you, Joe Biden, go talk to the Mexican president and get this started up again, toot sweet, which itself is wild. And I think a lot of legal observers thought, well, the Supreme Court's not going to go for this. This is so aberrant. This is so out of nowhere. This is so sort of poorly reasoned. Like, they're not going to okay this. And then last night, 6-3, the Supreme Court was like, yep, listen to the good man. Listen to the district court judge. Go start this Trump program you discontinued.
Yeah, and the court was very clear here. They relied on an earlier decision that liberals had actually cheered, the Department of Homeland Security versus the University of California Regents, which was the DACA decision from last term that said that the Trump administration could not rescind the DACA program lawfully unless it provided adequate reasons, which the Trump administration had failed to do. Liberals cheered that opinion, but the Supreme Court giveth and the Supreme Court taketh away. And so in this particular decision, it said that the Biden administration had not provided adequate reasoning for why it wanted to end the Remain in Mexico policy.
But is that true? Like, it does seem to me like there's a big difference here, both in terms of the reliance interests, like who's on the ground, the fact that the program's essentially discontinued, whereas DACA was functioning, and the lawyering the Biden administration did versus the Trump administration.
There are a lot of differences here. So all of the things that you suggested, the two programs were not in the same posture as they went up on appeal here. The other thing that's really different was that DACA case was on the merits docket. So there was full briefing, there was full oral argument in that case. It wasn't a shadow docket decision. It wasn't a decision where the court issued without giving any guidance. And here, the court really provided no information, no guidance to the administration as to how to explain what was inadequate about its original explanation.
Yes. Judicial activism is what liberals do. Judicial restraint is when a random district court judge tells the president of the United States to start negotiating with Mexico and restart a program that had been discontinued in a week. That's what judicial restraint and originalism looks like. Melissa Murray, thank you very much.